Good day, Internet. Chavez and Valko here, your full service immigration law firm. That means we do everything U.S. immigration. My name is Benjamin Hamilton. I'm a senior associate attorney. With me is Andrew Craven, associate attorney. Good day, Andrew. How's it going?
Going good, Ben. How are you?
Doing well. And if you see us too, that we are talking all things employment based immigration, whether it be all the way from students to investors, everything in between. And today we're going to be talking about a category that on its surface looks amazing. It looks like it is the lifeline to every business in the United States, especially right now when all that anyone can talk about is I can't get enough employees. Unfortunately, the way the program has been set up doesn't work very well. And it ends up not being usable for a lot of people. And that is the H-2B temporary non-agricultural workers. That's a mouthful. Don't confuse it with the H-1B, which is for professionals we hear a lot about. These are all like our IT guys and anything professional. Or the H-2A, which is for agricultural workers. Of course, non-agriculture is in the name. This is for the H-2B. So, Andrew, what is our sort of general definition of an H-2B?
So the broad definition is just someone who's a citizen of one of the listed countries that can be employed in the U.S. to provide temporary or seasonal services or labor.
So I would say the majority of visas are available to everyone. There's obviously some exceptions like the TN and the E visas. And it turns out also the H-2B that it is not available to everyone. There is a list. So what countries are listed?
So there's a little over 80 countries that are listed, and you can find these on the USCIS website. Some of them include Mexico, Honduras, El Salvador, Israel, some other random ones.
I remember the other day I was looking at the list and like India was not on the list. So there's some big names on the list. Obviously, when it comes to just actual usage, you tend to find that the overwhelming majority of H-2Bs come from sort of like Mexico and Central America. But if you are interested, check the list to make sure your country is on it. So one of the very, very key words that we're going to actually have to delve into and talk a lot about is temporary. These have to be temporary positions, whereas the vast majority of visas can be full-time positions, and you can request up, 2 to 3 years for most visas. These have to be temporary. So, what is temporary?
So temporary is actually grouped into four different subgroups. So there's a one-time occurrence, seasonal need, peak load, or intermittent need.
Yeah, so let's kind of jump into these. So one-time occurrence, that's something that we don't see all that often. Um, but what do they define as a one-time occurrence?
So basically, this is something that's only going to happen once. So the company that's going to employ these folks has to establish that they're not uh, employing workers to perform services or labor that they've done in the past, or that they'll need workers to perform in the future, and that the employment situation is otherwise, temporary. So basically, something for a short duration that's been created once.
The important thing is it can't have existed before and it can't exist in the future. It really has to be a one-time occurrence. I think one of the kind of classic examples is if they um aren't the Olympics coming to I think Los Angeles here in the near future. So something like the Olympic Games, right? Those jobs did not exist before. They will exist for a certain period, and then they're gone, right? And so like something like, hey, we need to bring in H-2B workers for the Olympics, would fall sort of cleanly into a one-time um, occurrence. Um, here's the one of the, I guess one of the questions is how long can a one-time occurrence be for?
So a one-time occurrence technically can be up to 3 years, but that generally also involves that the employer is going to renew it each year.
Yeah, so you're going to find that the other three categories, the one-time occurrence is obviously much shorter, under a year, or I mean the temporary need is under a year. But for the one-time occurrence, it can be up to 3 years. Now, let's jump to sort of the most common one that we see and deal with, which is a seasonal need. So what do they see as seasonal?
So this is services or labor that traditionally are tied to a season of the year, or the other term they use is like an event or pattern of reoccurring nature. So things that would be considered seasonal are, basically you also have to prove that there's going to be a complete shutdown for the other seasons. So this would be things like skiing season. You need people to staff your lodge or lifeguards in the summer.
Yeah, so this is one of the first catches that people run into. They're like, "Man, I have a restaurant and I'm desperate to staff it. I can't find enough people. This H-2B thing sounds amazing, right?" Well, one of the first issues you run into is, well, can you prove that your restaurant operations have a seasonality to them? Because a lot of people come back and say, "Well, no, I mean, it's a year-round operation." Well, in that case, you're not likely going to get approved for an H-2B unless you can actually prove seasonality. Now, you look at, like, sort of like resorts, they are, can usually show that there's this huge increase during the summer and then a substantial dip during the winter, and they can prove seasonality. So, Andrew, throw out the question. What is like the number one used category, not in terms of temporary need, but in terms of actual worker category for the H-2B program?
I would say seasonal, isn't it?
Well, I'm talking about the actual worker, like the job code. Like, what's the um, most commonly used job code or area of work? I guess you could say.
I would say construction.
Actually, not. Um, one of the most, actually, I think the most common involves like landscaping and irrigation and stuff in that. Construction is actually farther down the list than I thought. I think it was fifth or sixth. Um, and there are some involving but anyway, the idea is you have to show that it's seasonal. So you look at like landscaping, that tends to be during the summer, and then hey, I have, you know 3 or 4 guys during the winter, but then that needs to go up to 30 during the summer, right? And so you're saying, oh well, that you can show that you have this seasonal need, and you can sort of try to fill that gap between the permanent staff and the demand you have over the summer with the H-2B. But again, we have to be able to look at your sort of, again, the easiest way is to look at your financial data and just chart it and show, hey, there's this big mountain during a period, and then there's a valley during this other period. So one of the other needs is a peak load need. What's a peak load need?
So this would cover situations where the employer has to supplement their regular permanent staff who ordinarily provide the same services or labor, um, with temporary workers due to seasonal or short-term needs. So this would be like a toy manufacturer around Christmas that suddenly, gets more demand than expected.
Well, you think the toy manufacturer's probably ramping up production for Christmas, what? Probably in the summer, maybe, or late fall. But yeah, I mean, you can see. So there's a lot of overlap between seasonal and peak load, right? Because seasonal can be someone where, like, I'm closed for 3 to 4 months out of the year, like close, close. I have no workers, and then I'm open and I need to fully staff, right? Whereas peak load can kind of be the same, where it's seasonal, but I'm open year round and I have a core year round staff. Like, again, like let's say I have 10 employees year round, but the summer I need to go up to 50, right? That would maybe be more of a peak load argument if you have a year round core staff. But peak load also includes short term demand. Like you said, like maybe with the toy manufacturer, But the toy manufacturer could be seasonal, right? It could be that every year around a certain time, production goes up as they're preparing for Christmas. But it could also be something like, hey, we have this normal level of work, and it turns out we just released this new toy that was just a smash hit that we didn't really expect. And we need to quickly ramp up production to meet demand. But this may not be obviously something that's going to happen every year because it has to do with just like one toy. So, kind of the main difference between I think peak load and seasonal, because there is a lot of overlap, is that peak load also includes that kind of short term demand, which may be kind of a 1 year thing, where seasonal can be an every year thing. Um, then the last one. So, what is an intermittent need?
As this when an employer has not employed permanent or full-time workers to perform the services or labor, but occasionally, intermittently needs those temporary workers to provide, excuse me, perform services or labor for short periods.
The intermittent one's a little bit, I don't know, a little bit more difficult to wrap your mind around. But I think the difference is that when you're looking at seasonal, there's like a season, right? So there's like 5, 6, 7 months, whereas intermittent can be a little bit more like shorter periods of time, but maybe a little bit more scattered throughout the year. But you do have to be able to back up. When I say back it up, not only back up the temporary need, but you also have to be able to back up the number of workers you're requesting. So if you're like, hey, I need 10 guys, you got to be able to provide documentation to back up why you need 10, or 50 or whatever the number is. So we already said that the one-time occurrence can be up to 3 years, but all the other ones, when we're talking about temporary need, how long is that temporary need?
Since generally 9 months is the maximum.
Yeah, so 9, 10 months is kind of the max, right? Is what you can do. So the idea would be is that I would bring in people for 9 to 10 months, and then they would leave for 3 months, and then we just do it all over again. If it was like a seasonal, we just you could do this every single year if you're like a landscaping company, or like a resort. Um, so what about the actual employee themselves? Like, let's say hypothetically, I come in and I get an H-2B to work at a winter resort. But then as that period's coming to an end, well, I find a summer resort that's willing to essentially like swap me over to them. So you could have where an individual employer, their need is 9 months, but the employee could hypothetically bounce back and forth. So how long can an employee essentially stay in the US if they're able to pull this off?
So if they manage to pull that off, the maximum is 3 years. And this, like we've talked about with some other visas, well, specifically the H-1B, anytime outside the US is not going to count towards that. So if you say are here for uh, half a year, 6 months, step out for 6 months, come back for 2 more years, then you would still have 6 months left.
And how do they reapply essentially? How do they reset their status?
So to reset their status, you would just need to step outside of the country for 3 months, and then you would be eligible again for H-2B status.
So if I've been here bouncing back and forth between the summer resort and the winter resort for 3 years, we're going to hit a point at which the resort may get their approval, but if they try to file an extension of status for me individually, me specifically, USCIS is going to say, this dude's been here too long. And the only way to get around that is you have to leave and be physically outside the United States for 3 full months. And then, of course, you could reapply for a new H-2B visa and come back in and I guess do it for another 3 years. Um, so, are there any restrictions on the sort of type of work covered under an H-2B?
So it actually can include professional, skilled, or unskilled labor, although generally it does fall more towards the low skilled or unskilled uh, types of employment. But it does have to be full time and for a fixed period. You would also need to basically set a work week that doesn't have to fall on any particular start day, but you would have to, make sure that you are employing them full time for that work week.
Yeah, so this is why the H-2B is that on its surface looks like this great option because all the other visas are geared towards someone being a professional or someone being an investor or an entrepreneur or being an intra-company transfer. So when you're just like, hey, I just need workers, right? You know, the H-2B is really the only sort of option for low skilled or unskilled labor out there. So yeah, I mean, it pretty much can be used for anything that you can show has a temporary need. Um, so now we're going to get a little bit into the process and some other questions around the process because this is where you're going to kind of see where this sounds like a great option, but then it kind of falls apart in terms of just the usability of the system. So when can essentially an employer try to apply for H-2B approval?
So, like the H-1B, there's a lottery, but there's actually two lotteries for the H-2B program, and they set it up to the first and second half of the fiscal year. So, the first one's going to be October 1st through March 31st, and then April 1st through September 30th. And each time there's a limit on the number of visas that can be issued, and that's split up too. So it's 33,000 for each half of the fiscal year for a total of 66,000. And ultimately, you have to go through the process of entering the lottery.
So, um, the first thing that kind of blows people's minds is they hear, "Wow, this is a great option. Think about all the employers that could take advantage of this." But then they hear, "Oh, wait, you're limited to 66,000 a year. That's it. 66,000, that's it." That blows a lot of people's mind. Now, there are some exceptions in there, and it varies from year to year because it's an exception that kind of has to be authorized. But there are exceptions for like returning workers that in some years they've said, hey, a guy that was had an HGV last year and is coming back isn't going to be counted against the cap, right? And there's it's broken into two quotas. There's the October quota, which is basically everyone that has kind of a winter temporary need or seasonality, and then April, which is kind of like this the summer seasonality. Well, Andrew, guess which one of these has way more applications and way more usage, right?
I'm gonna guess the summer.
Exactly. So, the last couple of years, Congress has actually come in after the fact, like in May, and authorized an additional like 20, 15 or 20,000 visas, which again, still wasn't nowhere near enough. But um, one of the things that people have to understand is that we'll get into this a little bit later, but when we say lottery, there's usually not a lottery for the October window. As long as you sort of file on time, you'll if everything goes right and you prepared your case properly and all that, you'll probably be okay. The lottery, or so there's a quota, but not necessarily a lottery. The lottery definitely happens in the April window because they get so many applications so fast that they eventually have to stop receiving applications. This usually happens in February. And again, we're applying for April. And then they say, we're done. We're not receiving any more. And actually, we've already received too many. And now we're going to conduct a lottery of the ones we've received. So there's the possibility of if trying to go for the April window, doing everything right, and then just not getting selected. Same thing happens with the H-1Bs. So the H-2B April window is a very competitive, very competitive. But you can't just say, well, then I'll do the October unless your seasonal demand lines up with it. So if you're a landscaping company and you're like, well, I'll just do October, it'll be easier, right? Well, no, your season's not in October, November, December. Okay, coming back to some of the base requirements. Wages. Can I pay these guys just minimum wage or what do I have to pay them?
So you actually have to pay the prevailing wage, and ultimately the way that the law is written is that it has to be the higher of the state minimum, federal minimum, or the prevailing wage. But ultimately, because everyone has to pay, above minimum wage anyway, the prevailing wage is going to be the highest.
So let's actually look this up really quick. So in Texas, minimum wage is the federal minimum wage. It's 7.25, meaning in Texas, you're paying the prevailing wage, not the minimum wage ever. But if you're in some of these places, like I don't know, Seattle, that has like a $15 minimum wage, you may actually be paying the minimum wage, not the prevailing wage. The prevailing wage actually may be less than 15. So I am going to bring up a random one here for landscaping and groundskeeping workers, because it's the most common one out there that I tend to see. And we're doing this for Dallas. So obviously, if you're in other places, these numbers may be a little bit different. 373011. Here we go. Andrew, any guesses? Any guesses on what the prevailing wage is?
For groundskeepers in Dallas, I'm going to guess 1250.
Ooh. So the level one wage is 1350, but the mean wage for H-2Bs is 1649.
Ooh.
So yeah, even if you were in a place that had a higher minimum wage, you'd still have to go with the prevailing wage. So 1649 in this specific case, right? Again, this varies depending on what your job code is and where you're located. But these are all numbers that we get from the Department of Labor. So again, in most places, especially like Texas, you're not getting paid minimum wage. You're getting paid the prevailing wage. All right, so let's break down the process a little bit. Andrew, so when me as the employer, I want I'm a landscaping company. I want to bring in 20 guys for the summer. Do they just go apply for the visa? Do I submit an application to USCIS? Where do I start?
So ultimately, you're going to start with the Department of Labor. And the way it's going to work is you start with the registration process, then you're going to obtain the prevailing wage determination, and then finally, you're going to file the job order and the H-2B application.
So let's jump through some of this just kind of briefly. I first need to get a prevailing wage determination from the Department of Labor. The prevailing wage determination is you're essentially just submitting the job to them. So nothing about the employees, nothing about the temporary need, none of that. It's just here's the position, right? And the Department of Labor takes what you gave them. They take a couple of weeks, and then they come back and they say, okay, well, this is the corresponding job code, and this is the prevailing wage, right? So it takes a couple of weeks. You get that back from the Department of Labor. Once you have that, then you then go back to the Department of Labor and say, okay, here's our actual labor certification application. That's where now you're saying you're justifying how many people you need, the temporary need. You also have to submit a state workforce agency ad, and then once the Department of Labor receives your labor certification, you'll get like a confirmation email, and then once you get that confirmation email, you have 14 days to run recruitment. And the recruitment is 2 ads in the newspaper. And these ads actually tend to be kind of expensive because there's a ton of required language. And of course, ads are by the word. So they tend to be quite long. So you have to do this whole rigmarole where I have to get a prevailing wage determination and then turn around and get a labor certification. That all takes time. And if you were doing this in the April window, you can have no mistakes, no delays. I mean, you got to file that prevailing wage determination and pretty much have that labor certification ready to file the same day the prevailing wage comes back. Like you can't have any delays, any hesitation. You got to bam, file that thing. So here's my question. When can you start? When can I file the first part, the prevailing wage determination? So April window, when can I file that prevailing wage determination?
Um, April window. So I would say,
Well, there's an actual like number of days.
uh, isn't it 180?
Well, it's like 150 to 120 days. So for the April window, it's literally January 1st. And I kid you not, while the rest of you all partying on New Year's, there's immigration attorneys out there sitting at their computer waiting for the clock to strike midnight so they can click submit on their prevailing wage determinations because it's kind of a first in, first out. So you want to like submit right on if you want to get it out. If you're doing it for the October window, you're filing your prevailing wage determination in June, like around the 3rd of June, is when you're filing. Again, this is if you want to get in the door as quickly as possible. And for the April window, you have to be in the door as quickly as possible, or you're not going to get through. When you get to the labor certification, second step, it has to be within 90 to 75 days of the need of the start date. So again, there's all these weird timing things of when can I start and all these restrictions. Okay, so filed my prevailing wage determination, came back. I turned around, filed my labor certification. I also did my state workforce agency ad. I got notice that they received it. I did my recruitment. The Department of Labor approved the labor certification. So now, great, I have this labor certification from the Department of Labor. What do I do with that? Where do I go next?
So after you have the certification from the Department of Labor, then it's time to start going to USCIS and start actually applying for your H-2B workers.
And this is the key step. Now, a lot of times when you're submitting your application to USCIS, you're putting the number of workers that the DOL approved. Let's say it's 20. And if these guys are all outside the US waiting to apply for the visa, then there's no named beneficiaries, right? You're just submitting for 20. But this is the key. This is the application to USCIS is what has to be received before they close the window, right? Again, for October, this really isn't an issue because a window doesn't tend to typically close until November. So you start in June if you start at the earliest start point. But if you get delayed and you end up not filing your thing with USCIS until like October, you'll probably be fine with the April window. You're starting in January 1st, and you're hoping, by God, to file with USCIS by the end of February at the latest. Because if you are pretty much past that, I mean, by March they've already closed the window. So the key is it's getting through the Department of Labor and then filing with USCIS. Because if USCIS accepts your petition, then at least you'll be considered for the lottery. If you get to USCIS late, they're the ones that will reject you and say, "Sorry, we already closed the window." So then if USCIS sends you an approval notice, hey, here's an approval notice for 20 dudes, then what do you do? Again, we're considering these guys are all outside the US.
Um, well, then at that point, you would need to start filing the DS-160s to start like actually getting the visa process ready, right?
Yeah, I mean, you send a copy of the approval notice to each of the people that you've recruited, and then they are going to go and apply for the actual H-2B visa. So there's a number of things that kind of go into this whole process. Andrew, what's some of the stuff in terms of like sort of evidence that we're having to submit throughout this process?
So some of the things that need to be included, the time period for which you're expecting the project to last, the number of positions sought for the registration, the explanation for basically the need for these employees. And then you have to justify either the one-time occurrence or, one of those other, the seasonal peak load intermittent need. And then also you have to include the job contract that kind of explains the seasonal or one-time occurrence if that's the case.
Yeah, so the main thing is that, I mean, obviously they're very specific in terms of where's the job going to be located, what are the exact hours going to be. Um, you have to be able to actually prove that it's seasonal, prove the number of guys you need. Sometimes maybe you're just submitting contracts. Hey, I have X amount of contracts. Each contract's like, 5 guys and they're needed to work it. And so that's why I need 20. Like you have to be able to back all this stuff up. Now, I sent you something about the employee rights. This is an important thing, right? To know for both the employers to know what are their obligations to the employee, and then of course the employees want to know, well, do I have certain protections, right? Because you could think, oh, I'm going to bring in a bunch of guys from Honduras, and could be sort of ripe for abuse, right? To maybe not pay these guys what I'm supposed to pay them, or some mistreat them. So, are you looking at this thing about the employee rights from the Department of Labor?
Yep.
By the way, in case you're interested, you can look this up. and you can find it's a very detailed like flyer from the Department of Labor that lays these all out. So there's certain, for example, there's certain disclosures, right? So the disclosures are, the employee has to receive, written information about the wages, the hours, the working conditions. Um, they need to receive this before they get the visa, and if they don't speak English, they have to also receive it in their language. I mean, first and foremost, essentially, the employee has to receive a contract that lays everything out. Andrew, what about wages? What are some of the obligations regarding wages?
So, I mean, one of the big ones is it has to be paid at least every 2 weeks. They have to be informed in writing of all deductions, basically to prevent you from charging them, excessively for tools, things like that. They have to receive itemized written statements of earnings. So basically just a pay stub explaining whatever taxes or, Social Security was taken out. Um, and they have to be guaranteed employment or payment for at least three-fourths of the hours promised in the job order every 12-week period. So basically, you have to set out how long they're going to be working from the start and then ensure that they're meeting those hours to a degree.
Yeah, so three-fourths, right? Meaning essentially you can't bench these guys. You can't just bring them in and then it's like, oop, I don't got any work. Sorry. I mean, if you don't have any work and you can't meet the three-fourths, then you should probably be sending these people back home. Otherwise you're gonna get in trouble. Yeah. So in sense of you can't really deduct anything. Um, and of course it has to be in writing, anything that is deducted from their wages. They gotta be paid every 2 weeks. They gotta get it, they gotta receive a pay stub. So you can't just like backload it and say, oh yeah, we'll just pay you at the end of the, end of the summer. It's like, no, you can't do that. So another one here is transportation. So first and foremost, the employer has to pay for the transportation from their home country, to the job, right? Now they don't necessarily have to pay that up front, right? It says that upon completion of 50% of the job order, reimburse the reasonable costs incurred for transportation and subsistence from the worker's home to the place of employment, right? So, meaning most employers tend to just kind of pay for it up front. But if they don't, let's say the worker has to pay their own way to get to the U.S., the once 50% of the job order has been fulfilled, the employer has to then reimburse the employee for the reasonable cost of getting to the job site. And that also includes, the transportation itself, meals. If there, it also includes costs for all visa, like applying for the visa, right? Because there's like a visa appointment fee. There's like reciprocity fees, depending on whether or not you come via air or land. There can be like a fee at the border. So any like visa related fees, and those must be paid in the first week of employment. So basically, when they arrive, they should hopefully bring like if the employer hasn't already paid for it up front, they should bring their receipts and then being reimbursed for all the visa fees. Um, Also, upon completion of the job order, or if they're dismissed early, the employer has to pay return travel, right? So you got to pay to get these guys not only here, but you can't just say, okay, job's done, thanks, good luck. No, you have to send them back. That makes sense because otherwise, if you don't, they could overstay and that creates a whole other issue. Um, so, Andrew, there's some additional provisions here. So, uh, what are some of those additional provisions?
So like I mentioned earlier, you have to provide tools, supplies, and equipment at no cost at all. The tools required for the job. They also have to be free from discrimination or discharge for filing a complaint, testifying, or exercising their rights in any way, or helping others to do so. So basically, you can't, discriminate against them based on all the usual stuff. Race, religion, what have you. They have the same rights as other U.S. workers. Um,
Yeah, and you can't discriminate against them for like essentially, hey, because you can go to the Department of Labor Wage and Hour Division to file a complaint, and of course, if someone's trying to exercise their rights, you can't fire them for that. Um, there's a lot of like, there's a bunch of like must nots in here for the employer. For example, the employer should not request payment for their costs associated with getting the H-2B visa. So, hey, I had to pay my attorney to get this labor certification. I'm gonna, you know, it cost me $5,000, and you know what, I'm gonna like, I don't know, break that up across the 10 guys I got and kind of back charge it to them. Every month I'm gonna take out, I don't know, extra $50. You can't do that. You cannot deduct your costs in getting the labor certification from the employees. Can't do it. Um, Another important thing is when you get the labor certification, it is tied to a geographic location. So if you get H-2B for a bunch of landscapers to work in Dallas in the middle of the summer, you can't just be like, "Hey guys, let's go to San Antonio. Let's go to Austin. Let's go to Houston." You can't do that, right? You would have to have a separate labor certification that covers those other areas. So you can't just like move people. We've had that scenario where we had to like basically request multiple prevailing wage determinations and multiple labor certifications to cover an employer that was sending people all over the place. Um,
Right. I mean, the big reason for that being that you don't want to have someone basically pick an area with a lower prevailing wage, start work there, and then shift them to some place with a higher prevailing wage. So, say
and this
moving
is
from
not
like,
well, yeah. So yeah, you don't want to like, oh, I'm gonna get a prevailing wage for like Houston, and then I move them all to like San Francisco. I mean, you're gonna have vastly different prevailing wages for those two for good reason. Um, Another one actually really applies to the employer and U.S. workers, right? Where the employer must hire any eligible U.S. workers who apply. Remember, they have to conduct recruitment. They have to run a state workforce agency ad, and they have to run 2 ads in the newspaper. Um, and so, any worker who applies based on those ads until 21 days before the start date, they have to be hired. So you can't just say, "I need these 20 guys," and then some U.S. worker applies, and you're like, it's like, no, you have to hire him, and now you only get 19. Um, that's just kind of the way it works.
right, a
Anyway,
lot of these.
the important thing.
Oh, I was just going to say the rules really seem to be broken down to start with, protect U.S. workers, like a lot of the immigration laws are. And then second is, especially in the H-2B category, because there is a lot of low skilled labor, really protecting the foreign workers that come in and preventing,
Yeah.
abuse towards them.
So the labor certification is really what's supposed to protect U.S. workers, right? Because you have to go out and try to find U.S. workers before you can get these guys. But then once you get these guys, there are a ton of rules in place to protect them. So the important thing here is if you are the H-2B worker and you're watching this video, know that you have rights. You can find them fairly easily on both the USCIS and the DOL website. And the DOL has numbers that you can call to report any issues. Now, one thing I want to throw out there is what we have not talked about, we will probably do in a later video, is the H-2A, right? These are for agricultural based jobs. The H-2A, while they're very similar in terms of the application process and it has to be seasonal work, there's a lot of differences in terms of some of their rights and provisions related to employees and how they treat them. So if you're like you're watching this and you're like, wait a second, you didn't say that the employer has to provide housing. Well, that's because that applies to H-2As and not H-2Bs. So we will, discuss that in a later video so we can go through maybe some of the differences between the H-2A and the H-2B. Um, the main thing to understand is you do have a lot of rights and protections as a worker, and as the employer, you have a lot of obligations and stuff you have to meet in order to participate in this program. Otherwise, you could end up facing fines as an employer and potential debarment from the program. You're no longer allowed to use it. H-2Bs. So, quick question: I got offered a job to come in and work on an H-2B. Can I bring my family?
Yes. So same as the other age categories, H4 dependents for spouse and children.
So the main thing to know about the H-2B is that on its surface, man, it looks like this wonderful option for all those employers out there that are just desperate, desperate, desperate to hire people, and they can't. Especially right now, it's insane. Every single day, the people I talk to, and every time they say, "Man, I get these guys from like Central America, and they work really hard, and they don't complain. They're great. I wish I could get more." The H-2B is an option to do that, but you have to jump through. You have to understand you have to jump through a lot of hoops in terms of going through the whole labor certification process. Could be subject obviously do the lottery in the April window. You don't know if you're going to get it. But for employers who are willing to take the shot, it can be a great option because you could bring in 20, 30, 40, 50, whatever you can justify people to come in and work. Now, one thing we want to address, the question here is, hey, if I have an H-2B or an H-2A, can I apply for residency, or is there a way for me to apply for residency? Um, yes and no. So, is it, here's the thing: could an employer do a residency process for an H-2B employee? Yes, right? The most logical one would be the perm process, which we're going to discuss in a later video, but it does require them getting a labor certification and all of this stuff like they do for the H-2B itself. Two issues. Issue one is that the H-2B is a non-immigrant visa, meaning you're not supposed to apply for residency if you have an H-2B. There are ways, if you carefully manage the process and the timing, to make it work, right? One way is for the employer to run the perm and do the whole residency process, but then request consular notification or consular processing, meaning that once everything's set up and approved, the employee will apply for residency not from within inside the United States, but actually at the U.S. Embassy or consulate abroad. In Mexico, this would be Ciudad Juarez. Um, so it is possible, right? The other thing would be file for residency here, but you'd have to be here in status, and we would recommend you have been here for at least 90 days. But part of the problem is that if part of that residency process has come through and is right at the same moment you're applying to renew your H-2B visa and they see the residency process, they can deny the H-2B. So is it possible? Yes, but it has to be carefully managed. The timelines just have to be carefully managed, and you may have to consular process the residency. Now, the second problem I want to just throw out there is getting the perm itself. Hypothetically, you can do a perm for any level position, right? From a CEO, I guess, all the way down to just like, a guy working landscaping, whatever. You can do a perm for anything. The hardest part of the perm, though, is getting through the recruitment phase. Meaning, if I'm doing a perm for this one guy, and it's one position, and I go do all the recruitment, and a qualified U.S. applicant applies, I'm done. I have to stop the process. Now, normally we do perms for like higher level positions, for like professional positions. Oh, I need a bachelor's degree in X plus 3 years of experience. And because of the specificity and level of experience and education required, we're able to eliminate a lot of potential applicants, meaning people apply, but they don't qualify, right? They have the wrong bachelor's degree, or they have the degree, but not the experience. When you're talking about your typical H-2B position, they're pretty low level positions, meaning my only qualifications are you breathing? Can you show up to work and lift something, right? Meaning, if just about anybody actually applies for that job, you're done. You're not going to be able to get it through. So, can an H-2B apply for residency, be sponsored by their employer? Yes, but there's some risks at the perm stage, right? When you're doing recruitment of not getting through. And again, there's ways to manage that in terms of how many positions are you requesting? Like, I really want this one person, but I actually have 5 open positions. So if a qualified American does apply, it actually doesn't stop me because I have 4 other positions. Um, and then you have to carefully manage when and how you file for residency, because again, the residency application does conflict with the H-2B and can cause issues there. And the same kind of rules sort of apply to if it's family based, as to depending on, hey, I was here working as an H-2B and I married a U.S. citizen or something like that. Be like, well, I mean, if you're currently in the middle of your H-2B status and you're already married to the U.S. citizen, you may actually be able to file for residency. But if your H-2B status is about to end, or maybe you just left, like, we'd have to kind of look at how we would manage it. So the most important thing is hey, reach out to us if you have any questions or concerns. Obviously, you want to set up a consultation so we can look at your specific set of facts. Whether you're the employer and you want to see, hey, is this going to be viable? Can I use this? Can I apply? When? A lot of employers are probably looking at this and thinking, hey, April window, I want to talk to you guys and see if I can do this. Or if you're the employee and you want to know more about your rights, or maybe if you're one of these people that's in a position where they're willing to sponsor you for residency, or hey, you met your special someone who's a U.S. citizen. Come schedule a consultation, talk to us. We'll look through your specific facts and see if we can't figure out a plan that will work for you. Andrew, any final comments on the H-2B?
No, definitely. If you qualify, set up a consultation, or if you think you qualify, let us know.
Also, go download our app, Lawpilot GUARDIAN. It has a lot of useful information in there, a lot about knowing your rights, what to do if confronted by the police or immigration. There's a lot of news updates. Those features are all free. There are some great pay features in there too about, alerting your attorney and your family if you are detained. And we're constantly adding more features, along with like our case management system and all that. So again, the base app is free. Go download it. You can get it Android, AOS, wherever you may find it. Again, if you want to talk to us in more detail about your case, go to our website, set up a consultation, and we look forward to discussing your specific facts with you. But Andrew, thanks as always, and to the audience, stay tuned. We have one or two more visas to do, and then we're going to start in with the residency categories, and we're going to, we mentioned perm today, and we're going to talk about that in way more detail in an upcoming video because it is an extremely complicated process. But anyway, thank you and good day.